It's episode 5, probably. But this is the extra, this is the appendix, the extra bit. Now, if you know me, you'll know I'm a big fan of the live gig. You know, you've got to be there. You've got to soak up the atmosphere and the smell of the crowd and the roar of the grease paint or something along those lines. But anyway, one or two people haven't been able to get to some of the talks. So what we're going to do is, if the talks work out all right and a recording level, we'll stick them on here in their fullness. We are going to edit out the questions so people can ask questions as they like. But here's the full Death and the Law talk from Aisha and Richard, and we're very grateful to them both and to Evans Dairy's solicitors who gave them permission to come and share some of their expertise with us. So here is the full talk. It doesn't cover everything, obviously, you know, there's a disclaimer. Here's the full talk that they gave to us on Death and the Law as part of the Chelmsford Baptist Church season on Death and Glory. Enjoy!
Thank you very much for inviting us here. It's great to be here. I grew up in Chelmsford, so I'm a local lad, and I went through the doors at Evans Dairy, Road & Co. when I was 18 years old, which is over 30 years ago. So I worked at the shopping centre, and it's a momentous day for me today, actually, because I'm retiring from the practice, and today's my last day as a partner. So you've got me for the last day. I'm off to work for the government legal service after this, so it's great to be here. It's wonderful to have an opportunity to tell you a little bit about probate. I thought I'd tell you a story about a case which highlights why you should have a will, because many people say, do I need a will? You know, is it necessary? And for many people it isn't necessary. On occasions, you know, if you've got two children who are going to be inherited equally, you know, it passes according to what we call intestacy, which means that you don't need a will. But when there are disputes about who are the family members, things can get very difficult. And we had I had a case a few years ago in Chelmsford Wood where a chap had committed suicide, and he'd written a note saying, I want my estate to go to my daughter, and he gave her address. And it was quite clear who she was. And first things first, the letter was just signed by him, the suicide note, so it has no legal validity as far as a will is concerned. You have to have, for a will, two people witnessing the will at the same time, and you have to know that you're intending to execute a will. So that the fact that he'd written a note didn't mean anything. So that's the first problem, make a will. The second problem was that there was another young lady who thought he was his daughter. So two young ladies. Our client had sold the house. She'd got what we call letters of administration, which means that you apply without a will and you say, I'm the only daughter and I would like to apply for probate. So she got the probate and we'd sold the house and the money was sitting in our client's account. And then the second daughter, inverted commas, came along and said, well, I'm his daughter as well. I should be entitled to half the estate. I should be entitled to half the value of the house. So we've got a couple of £100,000 sitting in our client's account, and the conveyancer scratching their head saying, what do we do here? And we said, well, we have to wait until things get sorted out. So that she issued what's called a caveat, which means it stops everything going, and there had to be a big dispute about it. Now, how do we deal with this? Well, he was cremated, so there was no physical body sample that we could test for DNA to be able to establish the parental line between two. They shared the same mother, so obviously they had the same DNA mother. The question was, did they have the same father? So a blood test was done, typically, and that was inconclusive. That said, it didn't prove it sufficiently. So we were in a bit of a dilemma as to what to do. And the father's name was on the birth certificate of this second lady, so she'd got some pretty good evidence to say, well, his name was on the birth certificate. The birth certificate is usually conclusive, but my client was saying, well, we know that she's not the natural daughter, everyone knows it in the family, and she's just trying it on. So I went to Leicester University, and when I went to Leicester University, they were a world leader in establishing the genetic profiling for DNA. They actually, Professor Alec Jeffreys actually discovered it in his laboratory. He told me when I went to an open day, he said, literally, I was just, it was a late evening in the laboratory, and we just found this sort of strand of DNA, and that showed the genetic code of what family history is. And if you share a genetic code, it's completely unique to you. That's what the police use it in DNA profiling to establish if crimes have been committed. And you're thinking, well, where's he going on this? Because there's been a cremation, there's nothing there. But my client said, well, I do have his razor, and I do have the electric razor that he used to use with his stubble from his shaving. So we contacted Leicester University, and there's a Professor Turi King there that you've probably seen on TV, and she does all of these sort of family reconnection things and works out who are related. And a test was done, and it proved conclusively that the other lady was not the biological daughter of the father. So we were able to defeat that claim, and our client was able to have the whole house, so to speak. So that was a good example, I think, as to how you should have a will, because all of that would have been resolved. None of that would have happened in terms of the legal case if you'd had a will, because you'd have appointed an executor and you've said who's to have the estate. So I thought that was a really good case to sort of illustrate the importance of having a will, really. So I'm going to pass over to Aisha now. She's going to have a little chat, I think, about sort of the general aspects of probate. So I'll leave you to sort of have a little chat. Okay?
Good evening, everyone. Okay. So, how many want to admit that they've ever done a will already? Oh, well done. That's actually really good. That's really good. A lot of people, sadly, know the importance of doing a will, but it's not always the best conversation to have. It's not always the best circumstance to have to think about, and it does put people off for many years until, sadly, something happens and it makes them really realise that they'd rather do one now than it being too late. Richard's obviously just touched upon the importance of doing a will. By doing a will, you can put in black and white exactly what you want to happen, who do you want to include, who do you want to be in charge, and hopefully there's not that many issues about it. But as we know with everything, there can always be that someone that can come forward and contest the will. But the point is, if you start off with a will, at least you've got a good start and you have some kind of a guarantee that at least hopefully your wishes will be put into effect rather than passing away with nobody knowing exactly what you wanted to do. So I'm here to talk to you about half boring things, just so you're aware of what's out there in terms of services, what those type of documents allow you to do, just so it's something you think about, something you are aware you can get involved with, put in place, and how it can make your life easier. So with wills, when we meet clients, no two clients are the same. So each person, each client for us, they come with their own story. And it's really enjoyable for me when I have a client come and sit in front of me and say, don't worry, this is going to be straightforward. 1 hour later, we're still there talking about things. And that's what I love about it, because we make the clients think about situations which they may not have thought of. We raise scenarios which they may not have realised could occur. And we always suggest they think of backups, that, okay, if this couldn't happen, or if something happens and this person can't inherit, what would be your backup choice? So it's always very interesting talking to clients, and you'd appreciate those of you that have done wills. it's a very personal conversation that you have. You are sharing a lot of your personal details, whether it be about family, whether it be about finances. And we obviously take that very seriously, and we try and give you the best advice we can given that situation. But the advice always is, if in future, whether it be 1 day later, 1 month later, 1 year later, if your circumstances are changing, whether that be personal circumstances or financial, it's always worth reviewing your will, because you may want to do things differently, or the law may have changed, and you may take a different view on how you've done your will and where you want your assets to go. So there are different types of wills. You've got the more straightforward ones, then you do get the more complex ones. Again, when you have that conversation with a solicitor, they will be able to tell you and advise you what type of will may be more appropriate for your circumstances. And in that, we do, like I say, discuss family situations and financial situations. So with family situations, at the end of the day, you are the person who owns your assets. You choose what you do with it. But the law allows certain categories of people to contest the will. So there's always this debate on, do you really have free choice and free will as to where do you leave your assets and who do you leave your assets to? Well, yes and no. So to an extent, yes, you can choose whoever you want to leave your assets to, but the law does protect certain categories of individuals, such as spouses, children, and those that are financially dependent on the person that's passed away. And the law protects them and allows them to make a claim if they feel they've not been reasonably provided for financially in a person's will. But again, these are all things that happen after a person passes away, and there's only so much you can do to prepare for that. And a lot of the time what we advise is, it's a good idea, just on a separate piece of paper, jot down your reasons why you've done what you've done. You know, if someone possibly doesn't want to include a child or wants to favour one child over another, you know, everyone has their reasons and there's nothing wrong about that. Our job is to advise, okay, that's fine, but what could happen after you've passed away? And they can, like I said, jot down their reasons, and then if that ever needs to be used later, whether it be in court, then it just sheds some light on the situation and helps people understand why the person did what they did, rather than the judge just deciding, okay, that's fine, you made a claim, let's give you something. So, like I said, each case is different, and it's worth having that in-depth conversation, because there may be a few things there which you've not previously thought are important or need probing into further, but actually could do with giving a bit more attention to. So, like Richard touched upon, if you don't do a will, in some circumstances it may not make the biggest difference, but in many circumstances it might. And with the kind of family dynamics we are in these days, you know, there might be stepchildren involved, multiple previous marriages, there are estranged children, so there's, like I said, a lot of circumstances which go on. So by not having a will, something called the intestacy rules, which are government laid down rules, and they set out who should benefit from your estate. And it finds a next of kin, but that could mean a biological child who you've not had anything to do with for over 50 years. You know, this person now is equally entitled to your estate as that child that you've lived with your whole life. So it's always a good idea to do a will, because, like I said, you keep control to an extent as to what happens. And the main thing is that you can also choose the people that will be in charge to deal with your affairs. Okay? So they are called executors, and they are the ones that will make sure that the wishes of your will are followed through with, and they are the ones that make the decisions and make sure everything flows fairly smoothly after someone passes away. Another thing which we touch upon when we have that initial conversation is your assets, the financial circumstances, and whether there's inheritance tax to pay. Now, is inheritance tax a concern that anyone has ever had, or a question, or is it a term anyone's ever heard when they've thought about putting their affairs in order? So, so a lot of people, quite rightly so, are worried after they've passed away, you know, how much will the government take? And again, when you have those conversations with us, you'll be quite surprised as to the thresholds that the government do allow estates to claim. And currently, when a person passes away, their estate does not need to pay any inheritance tax on the first £325,000 worth. Okay. So if your estate, so if your estate is below that, then no inheritance tax to pay. If it goes above that, there may still not be inheritance tax to pay, and that's where the advice comes in. So if you're leaving your estate to a spouse or children, then that's where other reliefs, other exemptions can be used. So a lot of people that do worry about it, they come to us and they're quite pleasantly surprised as to the figures we give them based on their circumstances. And they know what figure to keep in mind. So if they ever do go past that figure or get close to it, they know to get in touch and have a review. And we advise that anyway, because you just don't know, the law could change the next day. So it's always worth just having a review. But inheritance tax is a genuine concern people have. And again, sometimes there's nothing you can do about it. But at least you are prepared and you know somewhat what's going to happen to your assets and your money after you pass away. The other things which Richard has touched upon is this term, grant of probate. Has anyone heard this term before? Yep. Has anyone had to deal with an estate or act for a deceased person at any point in their lifetime?
Yeah. She didn't leave a will.
She didn't leave a will?
No.
Did you get the help of solicitors or did you deal with things yourselves?
No,
King's Court.
King's Court Trust took it,
Okay.
and we gave them a lot of information, didn't we? They only had to find a couple of people, and it took 4.5 years.
Right. And
We
that's
didn't
one.
really go to the right people.
I mean, that's one prime example of had they left a will.
Yeah, we
There wasn't-
told them.
yeah.
We told
Yeah.
them. Leave it to the doctor, leave it to the horse.
So this is the message we're going to keep pushing on you today. It's important to do a will. That's a prime example. I mean, you do get some complex cases with wills that can take time, but there's always a reason. But when there's not a will, everyone needs to make sure the right people and all the right people have been found. Because the last thing you want to do is pay all this money out only for one beneficiary to come forward, which you didn't know existed. Only for you to have to try now and sort out the inheritance that you've already paid out and people may have already spent. Okay? So, it happens.
That's the secret, spend it all. Quickly.
Very true.
So a grant of probate, in effect, it's a document. It's an A4 piece of paper which the courts issue. But what's on the piece of paper is what's important. So it has details of the deceased and it has details of the people who have the authority to deal with an estate. Whether that be the executors of the will or whether that be the administrators if it's an intestate estate. So that document is what allows people to deal with the assets. And a lot of people, unless they've had to deal with someone's affairs, may not actually know the procedure that takes place after someone's passed away. I mean, sadly, in my career, I've had less than those people that have called literally an hour after someone's passed away because they felt the need the solicitor has to know. And then we get those that wait several months before they let us know. I think the right time is in the middle somewhere. I think straight away, there's not much we can do before we see a death certificate anyway, and that can take a few days to come through. But I think leaving it several months when there may be a lot of issues that need to be addressed, such as inheritance tax, which does have a deadline to be first paid within 6 months, those type of deadlines are starting to pass if you leave it too late. So with a grant of probate, it's a document then that allows people to collect in assets, so deal with properties, whether it's sell the property, transfer the property, collect money from bank accounts. So a lot of the banks, if there's a lot of money in the account, they will not just release the money, and rightly so. So they will ask for this grant of probate document, which for them is that ticket that they need to make sure they've paid it to the right person. What that person then does with it, that's on them. But at least they've paid it to the right person, and that's what the grant of probate does, make sure the right person in authority is the one dealing with the money. So that is what a grant of probate is, and there is an application that goes with it to obtain that grant of probate. And that's a service that we help with, and we help complete the application, get it signed by the correct people, get it all sent off to the courts, and get you that document. And once you've got that document, hopefully after that, it's just a matter of collecting in the money, paying everyone their debts, any liabilities, and then distributing the money amongst the correct people. There are some estates, again, just like with wills, with estates, after someone's passed away, no two estates are the same. So the assets a person has, the liabilities they have, they're all different, and the types of work we do vary on each case. So it could involve going through someone's property, arranging clearance, arranging valuations, getting auctioneers in to value items, personal possessions that they had, dealing with sales of cars, obviously dealing with bank accounts, premium bond shares, those tend to be the standard ones. But again, no two stories are exactly the same. And I have previously in my career dealt with what's called insolvent estates. So estates where there's actually not enough money to collect in and pay everyone out. So like I said, it varies, but the starting point always is do a will. And it's the easiest way to make sure the people you care about, the people you want to include, the people you want to benefit from your estate can get what you feel they rightly deserve. So in terms of the wills and the probate, that is a large aspect of what we do. And they are very important documents. And the one thing to bear in mind as well is with wills, is when you are doing a will, it is important that you have the relevant mental capacity when you're doing it. It's important that you understand what money you have, what relatives you have, you understand what a will does. It's important that you can retain the information. It's important that you can communicate that to us. You can weigh up the options and know which option is right. If you like, so there are different types of wills. So when you have that chat, different options are given to you, and it's important for you to know what fits you best. So capacity is very important because you can keep doing wills until the day you pass away. And we have had such people, and we call them serial will writers. So you do have them, they come back almost every year, but there's nothing wrong with that. If their circumstances have changed, if there's something different they want to do, by all means come back and do it. And the point is you can keep doing that until such time either you pass away, or you've sadly lost mental capacity and you're no longer fit to be able to change your will. Okay? So that's the important thing, and that's why it's something that you shouldn't leave too late, because nobody knows what tomorrow holds. And the sooner you do it, put your affairs in order, then if anything changes, by all means, update it, change it, but at least you've got something to start off with. So do a will. Again, the same message I'll be repeating several times. Apart from wills, actually before I go apart from wills, another thing a few people are aware of is after a person has passed away, so let's take a very straightforward example. Mr. has passed away and he left everything to his 2 children. Now, not many people know that the 2 children can change that. So they can actually change, in effect, the will. And it may seem really odd to some people that what is the point of doing a will if it's only going to be changed? But there are obviously limitations to who can change it and how much they can change it. Now this is called varying the will, and it's done by something called the deed of variation. And what it allows a person to do is, if you're a beneficiary and say you've inherited half of someone's estate, but for whatever reason you feel you don't really need the money, you don't want that money, then you have a right to redirect your inheritance. So you don't have to take that 50% if you don't want to, and you can actually redirect it. And it's actually quite a common thing done, and many people may say, we're well established, our kids could do with the money. So they can enter into this deed of variation, which again has limitations. It has to be done within 2 years of someone passing away, and it allows the beneficiary who's inheriting to redirect their inheritance only. So you can't then take your inheritance of someone else and say, you give yours as well. No, they need to agree to that themselves. All you can do is redirect what you are going to inherit. And it is a useful tool. Especially when you start talking about inheritance tax again, because you may have those grandparents whose children already surpass that inheritance tax threshold, who, if they were going to inherit more money, are only going to have to pay even more tax, but they've got children who actually are just setting out in life, could do with a bit of money, could get onto the property ladder, this and that. So it's actually a really useful tool to redirect the money, and it takes effect as if that was in place as of the date of death. So it's actually a really good tool to use, but again, it may not be for everyone. Not everyone may want to not take their inheritance. Many people would be happy to take it. But it's useful to know, because in some circumstances it's appropriate for individuals, and it just makes sense for them to do. But again, if you take the correct legal advice, it should be done the right way, within the right time frames, and executed correctly as well.
So you speak British, not got to go out of there.
Yeah.
So yeah.
And some other services that we do, it's not just wills, probate. We do other documents called lasting powers of attorney. Has anyone heard of lasting powers of attorney? Yep, great. So these documents, some people do get mixed up with the will. Now, they are done by the same department in many places, but they are two different documents and they have two different purposes and they run on two different time frames. So with a will, it's something you put in place and it only takes effect after you've passed away. Okay? Whereas a power of attorney, that is to be put in place to be used whilst you're alive. And as soon as you pass away, that comes to an end. So there's two different time frames that they have. Power of attorneys whilst you're alive comes to an end as soon as you pass away. That's when your will starts. Okay? And the power of attorney, the whole purpose is that, again, whilst you have capacity, you can choose people who you trust to take decisions for you should you be in a situation where you can't make those decisions yourself. So, for example, if someone loses mental capacity, no longer can they deal with their finances, but things need paying for, whether that be bills, whether that be care home, invoices, but someone needs to access the money, someone needs to shop for them, someone needs to get the money out to spend it on them. The banks will turn you away if you just turn up and say, yeah, they asked me to. So what they will always ask for is the authority, the legal document, and that lasting power of attorney is that legal document. And that document is what will name the people you've picked that you trust, and that will allow them to go to the bank, to access your finances, and to use them for your benefit in your best interest. And with powers of attorney, there are two types of documents. One that deals with the money side of things, so you've got the property, bank accounts, things like that. And then you've got the other document, which deals with health and welfare. So again, they cover two different aspects of a person's life. So the financial document that I was just talking about, there is an option there for it to be used with more flexibility. So should you want it to, you can use it even before you've lost mental capacity. Now, many of you may think, why would you want to do that? If I give you two examples, which I tend to give my clients. Firstly, if sadly someone suffers a stroke, mentally they may be absolutely fine. But speech is impaired, mobility may be affected, they may find it difficult to deal with finances, to go to the bank, to buy those paper bills. If they've got that power of attorney document and they've selected that option, which is the more flexible option, then they can just get their attorneys to step right in and start dealing with their affairs for them. Another example I use is in COVID times. A lot of people were asked to shield. Now, nothing wrong with them in terms of mental capacity, but they were physically restricted from being able to go out. Again, those that had lasting powers of attorney could easily get their attorneys, go to the bank, get this money out, go and shop for me, go and pay this bill, go and do that, no problems. Whereas those that didn't, unless they were using other means, which legally I can't say was the best thing to do, they were having problems. Okay? So with the financial document, it's there, it's flexible, and it's there because I think everyone's aware money is what keeps things ticking over. As long as someone's paying for it, it's fine. So it is an important document to do. And the health document, I think 10 years ago, I would have said you could get away with not doing it. So I would have said, it's fine if you're a spouse, if you're a child, that's fine, the doctors will listen to you. But over time, things have shifted. I think we've become a less trusting world. And spouses still tend to be okay when it comes to making decisions about health, but children are being turned away more and more. So unless they've got this power of attorney document, which has their name on it, giving them authority to make decisions, doctors will not just readily listen to children and say, that's fine, you've said it, let's just do it. Again, I don't know, is it because the dynamics are changing? More and more we're finding that children are finding it difficult to make these decisions without the document, which seems sad, but then again you get those circumstances where 30 years later one child rocks up to the hospital, makes a decision, only for everyone to say, who was that? So it's understandable, and that's why these days I do say that fine, if you feel you can get away with it for now, fine, but there may come a time where there is no spouse, and when it comes to children, more and more NHS trusts will say, actually, we need the document. And again, same thing with the will, you need capacity to be able to do this document. So the sooner you can do it and put it in place, at least it's there and it's ready. And I always say it's good to have the document and not need it, than to need it and not have it. I call them peace of mind documents. And yes, you may need to pay money for them and never need to use them, but at least you've got peace of mind. That's what you pay for. That should anything happen to you, you know people you've trusted will be there to make those decisions. Whereas if you didn't do a power of attorney, there's still always a procedure. But of course, it's always going to be more costly, more timely, and more hassle. So if someone loses mental capacity and they didn't do a power of attorney, then somebody needs to step up, whether that be children, spouse, a carer, local council, government, anyone. Someone has to step forward and ask the court for permission to deal with this person's finances. And as you'd appreciate, this could be anyone. So the courts are going to be checking in and out who this person is, what is their interest, should they be given this authority or not. That can take a very long time. And it can cost money, and it can be a lot of toing and froing with the courts. So why go through all that hassle when you can just do a document, pick the people you want, and put it all in place? Like I said, whether you need it or not, the point is you've got that peace of mind that you've done everything you can do to prepare for the worst. And they are difficult conversations to have, whether you're doing a will or whether you're talking about your power of attorney and the decisions people may need to make under it. They are difficult conversations to have, but again, no one's telling you to have them every single day. Okay? Having that one-off time, have that conversation, say what you have to say, and then you can put it to one side, unless something changes. That's when we always say revisit it, and just make sure what you have is up to date and relevant, and you're happy with it. And if you're not, let's do another document.
There's another little thing as well about advertising as an executor. When you take on the responsibility, it's a personal liability. So you have to make sure you pay off the bills, that the deceased has got, and you need to distribute according to the intestacy or what the will has to say. Now, you've distributed, and then up to 6 years later, a credit card company comes knocking on your door saying, what about the credit card bill the deceased owed? Well, you would be liable as an executor for that because you hadn't paid it, because the estate would be liable. More correctly, you could trace back through and ask the money to be paid back, but everyone would have spent it by then. So there's a good protection available to an executor where you can advertise for creditors. And you might see these little adverts in the newspaper about solicitors saying, the deceased Joe Bloggs, any claims, Evans Dairy Solicitors. Nice bit of advertising actually, because when you put it in, the firm's name's out there and when you're doing work. But what it means is after a period of time, after about 4 months, it is 4 months, isn't it? I'm not sure. I think it's 4 or 6 months. You put it in and it goes in something called the London Gazette. And the London Gazette is this mythical newspaper in London that advertises all the court circular, tells you where the King and the Queen's going, tells you about all the affairs of state, and then about page 700 of this month's edition will be Joe Bloggs, Chelmsford Wood Estate, Evans Derry. By complete mystery of law, that advertisement is a national advertisement, and that means that any creditor is on notice automatically of the estate. And if they don't come forward within the 4 or 6 month period, whatever it is, by the deadline, then you can distribute without fear of being personally liable. And many solicitors say to clients, you should place the adverts. It's not cheap. If you own a house, you should also place an advert in the local newspaper, like the Mail or the Post. And typically it costs about £300 to place the adverts. But it's money well spent to give you protection. At the end of the day, if there's a reasonable estate size, it's an administrative cost that has to be paid first before you divide everything up. So it's sensible to do it. But often we'll have conversations with clients who'll say, oh, I know my mum very well, she never was in debt, I know my dad, they wouldn't have done that. And they can make that decision, they can make that choice and not pay for the advert. It's not compulsory. But if you're taking on an administration for maybe a cousin, or when we are appointed as executors ourselves, for example, clients come in and ask us to be executors, we will always advertise because we know nothing about the affairs of the client. They might be very dubious, so we have to make sure that we've done the advertising. I think the care home fee issue about severing joint tenancy, do you want to mention that? Or is it a big... where are you out now, do you think?
Do people, so is that the care home thing might be interesting. Do people want a break or do you want to carry on? Yeah, so rapids.
Well, I'll pick up the care home fee. Often get
There's a film in this.
we often get clients who come in and say, I've worked all my life, I don't want it all going in care home fees. What can I do to avoid having to pay care home fees? I've been told I can give my house away to my children now, and that'll avoid it. And the answer to that is, yeah, of course you can do that. But if your child becomes bankrupt or gets divorced, that house, you might be living in it, isn't yours anymore, and the official receiver, who deals with bankrupt affairs, will want to sell the house and take the money for the debts, or the partner in the matrimonial split, the divorce, will be wanting their slice of the action out of the house. So it's very rarely do we ever suggest that's a good idea, because you are giving your property away. You might say, oh, everyone knows what we're doing, it's all, the bottom line is, it's beyond your decision at that point, because if affairs take place and things go on like that, then you've lost it. So the care home fee, or other thing, is it is a bit of technicality. It's about owning property, and it's about giving half of your property away in the first day. It generally only works for a couple, a married couple in particular, or unmarried couples can work for. So just bear with me. You own a property and you own it jointly, okay? That's a concept that we understand. And there are two types of joint ownership in English law. There's something called joint tenancy and tenancy in common. Now, the happily married couple who have just gone off on honeymoon will typically own it as a joint tenancy. They're in love and they're just going to go off and be happy ever after. And when one of them dies on holiday, the house immediately shifts to the other person.
It's a good turn, isn't it? That story.
It's like yeah. Well, I've had clients who've gone out swimming in Greece and they've never come back, and it's one of those things. So the joint tenancy, they go off on honeymoon, one of them dies, and they're a young couple. They've got loads of insurance. That house immediately transfers to the person. It doesn't actually transfer. It's like a joint bank account. You sign a cheque on a joint bank account, either you can sign it, can't you? When the one person passes away, the joint bank account just becomes the property of the remaining person. That's the same thing with a property held jointly. The second type of joint ownership is called tenancy in common. That's the type of tenancy that I would want with my business partners. If I die, I don't want my share of the house going to them, I want it going to my wife. So often with second couples, second married couples who've got second marriages and the rest of it, they'll own it as tenancy in common. We'll own it 50-50, 80-20. You identify what the shares are. So when that one person then dies, it doesn't pass automatically. You need a grant of probate or whatever to get that share that's been passed on. So that's the first stage of explaining to you the difference between tenancy in common and joint tenancy. The care home fee system that we use to try and mitigate care home fees involves severing the joint tenancy, so you own it 50-50. Just imagine it's a married couple, husband and wife, going to be very sort of traditional about the concept. The husband dies first. His half share doesn't immediately pass to his wife, because his will says, I'm going to give my half share in the property to my children. Okay? The wife then goes into care because she needs to be cared for. Her half share in the house can be used to pay for care home fees, but the husband's half share has been given to the children. So it's a perfectly legitimate way of planning how you split your property. And that first gift then by the husband's estate through his will to his children is preserved, and the local authority can't touch that because it doesn't belong to the wife. It's been given in the husband's first will. So that's often what we're asking. And that's about the only way we know of mitigating we've seen lots of trusts from very fancy financial advisors with very big waddy sort of trust documents. We don't think they've ever really been particularly good, really. They might be okay, I don't know. They charge a lot of money for it, but we haven't got into that at all. That's about the only mechanism we've used, really.
Okay. One quick thing to add. So like Richard said, sometimes that is the best that you can do, is after one person's passed away to protect half the share of the property. I also get lots of people come to me saying that they've heard of these schemes where you can just transfer all your property and it's safe. There's, like Richard said, things like bankruptcy. If you transfer your property to your children, say, if they go through bankruptcy, divorce proceedings, that house is up for grabs by third parties. But there are also other red flags that people need to be aware of. So if you were to, say, transfer your property to your children and then go into care, the care home, the local authority, they can ask questions as far back as they want to. There's no set rule that they have to only go back 7 years. They can go back 20 years, 25 years. They'll go back until there was a time when you owned that property. And they will ask you, well, what did you do to it? And you'll say, oh, I transferred it to my children. And they'll say, okay, did you carry on living there? You'll say, yes, of course. Did you pay rent? No, why would I do that? Okay, and that is the red flag. If you gift a property, but you carry on living there, and you never paid market value rent, for the local authority, they've actually got a term for it. It's called deliberate deprivation of assets. And if they feel you've purposely tried to give away your assets to try and avoid paying care fees, then although legally someone else owns that property, they can, for their purposes, count that property as if it was still yours. So that is the red flag. If you carry on living there and you don't pay market value rent, and we get something similar when it comes to inheritance tax. We get people trying to transfer property, because property tends to be the main asset, the largest value asset. So we get people, let's transfer it into children's names and you won't own it and you won't pay inheritance tax. But for inheritance tax, they have a separate term and it's called gift with reservation of benefit. So again, if you've gifted a property but you've carried on benefiting from it and you've paid no market value rent, then fine, it's going to be included in a different part of the full, but that full value is still going to be included and there's still tax to pay. So those are the red flags. So when you hear lots of these people say, oh, the scheme's out there, just transfer the property, it'll be fine. There tend to be a lot of companies that you won't be able to Google X amount of years later, so there's no one to go back to say, why did this not work? So it's always something to be wary of, and that is, like Richard said, the best that you can really do is after one person's passed away is to protect half the value of the property should the survivor go into care. I think trying to want to save the whole property, it needs to get to a point where you have to be a bit more realistic. If it can't happen, it can't. But I remember once my supervisor said to me that with clients, you need to just tell them what are they trying to do. In effect, people come to me and say, oh, we've worked our whole lives, put all our money into this property, and we don't want it going into care. And I now turn around to them and say, who is the care for? It's for you. If you need a good, high standard quality of care at that point in your life, why would you do everything you can to not get that care only so that there's something left for some beneficiaries? So it's that priority. If you've put all your blood and sweat into that property, don't you deserve the best care? Even if it means you're paying for it. So it's weighing that up. I think there was this big shift where a lot of people just wanted to do anything that they could so that they're not paying for care. But I think if you start to think about what you're paying for, what you're getting out of it, how necessary is it? And it's for those days of your life where you probably need it the most. And it is very important. And it will be very different for each individual. Some people need more specialised care, some people don't. But the point is, whatever you need, don't you deserve the best? So when it comes to the wills, that's the reality of it. The best you can really do is protect half the share of the property after one person passed away. So it works for care fees, it even works, if someone's passed away, the spouse then moves on in life. They get remarried, they can do what they want. That half share of the person that passed away, that's protected. And just, again, if the survivor wants to blow off the money, go on all these cruises, they can, but with whatever they own. That half share that the deceased person owned, that is protected. And that is a good tool to use, and it fits quite a lot of different circumstances. But like Richard touched upon, we get a lot of those circumstances where you've got families with children from different relationships, and they all eventually want something to go to their kids. But what they don't want is for their spouse to miss out on it whilst they're alive. And it's a really good tool because it allows a surviving spouse to carry on living in the property, benefiting from the whole property, but eventually, when they pass away, then the first person that passed away, their share goes to whoever they want it to go to, but the second person that passed away, their half share goes to whoever they want to. So in the end, it's fair, but in the meantime, you're not putting your spouse at a disadvantage by not leaving them the whole property.
Okay, thank you very much. That was good. Very helpful.